Yeah, because I want my gun back.
So listen. Before you
I'm not freaking out on you guys. Listen.
On May 5th, 2026, deputies with the St. Lucie County Sheriff's Office served an injunction on Second Amendment activist and YouTuber Michael Taylor, also known as the Armed Fisherman. Earlier that year, Mr. Taylor had been charged in Pinellas County, Florida, with stalking Clearwater City manager Jennifer Poirier and was found not guilty by a jury. Following the acquittal, Ms. Poirier filed a petition for a stalking injunction against Mr. Taylor in Pinellas County, and a temporary injunction was entered on May 5th, 2026. Because Mr. Taylor resides in Port St. Lucie County Sheriff's Office deputies were dispatched to serve the injunction. Mr. Taylor filmed the encounter and then shared it on his YouTube channel.
To contact. It says respondent shall have no contact with petitioner unless otherwise provided. It says respondent shall have no contact with petitioner, not directly or indirectly contact petitioner by mail, email, fax, telephone, through another person, or any other manner, including electronic means or use of social media. Further, respondent shall have no contact or have any third-party contact anyone connected with petitioner's employment or school to inquire about petitioner or to send messages to petitioner. That means no telephone calls, no text messaging, no Facebooking, no Instagramming, no Snapchat.
About her. About her.
You cannot contact her.
As long as I don't say nothing about her, I'm good.
You cannot contact
if I can talk all this shit I want to talk about Clearwater, but long as I don't talk about her directly.
You cannot contact her
directly
or indirectly.
Okay,
and not through another.
Well, no, you just said indirectly.
Yes.
Well, she works for the city of Clearwater, and I talk shit about Clearwater. So is that indirectly, or is that because as long as I don't say you're the
Look at me.
I'm looking at you.
I'm not an attorney. I can't give you legal advice. I can only tell you what the paperwork says.
This
not
is
indirectly not directly or indirectly contact the petitioner.
Of her. Long as I don't talk about her.
You cannot contact the petitioner. All right? Contact.
Okay, what else?
Number 3, firearms. It says respondent shall not use or possess firearm or ammunition.
What?
Listen. Respondent shall surrender any firearms and ammunition in respondent's possession to the St. Lucie County Sheriff's Department.
And she's not feral or anything like that. Right there.
Right there. What I'm going to do is I'm going to write a...
It's fine, man. Just take the gun and be out of here. I don't want to hear nothing else. Just if you got to take the gun, take the fucking gun.
Okay.
Thank you. Have a good day.
No other ammunition or anything?
No.
We're not being rude to you.
I know.
Try to be nice.
Please.
We got you.
Please.
We got you.
I know. I'm not being aggressive towards you. You've got my gun. We're done. Right? We're done. Right? We're done. Right? We're done. Right?
Okay.
Have a good day.
All right.
Yeah, because I want my gun back.
So listen. Before you
I'm not freaking out on you guys. Listen. Here, Linda, listen. Just give me my receipt and let me be about my day.
I gotta write it out.
What's your name?
You're gonna have it. Well,
don't say right here, please. What's your name?
Jose Estrada.
Thank you. Your name?
Deputy Arteche.
Thank you. And badge number?
319. I'll give you my business card.
It's fine. We'll go through all that. Your name and badge number?
Here's 200.
Thank you. Your name and badge number?
Sergeant Verveneer 179.
All right. And yours?
Lieutenant Flowers 134.
Thank you very much.
You're welcome. Thank you for being cooperative.
I'm not. I don't even know what this is. You are coming from Pinellas County.
No, we work for St. Lucie.
They sent you to come here from Pinellas County, and I just got found unanimously not guilty for what is going on. I was found unanimously not guilty, and now I got to deal with a civil suit.
It's not a civil suit.
What is it?
Okay. So an injunction is just it's a civil matter that still is resolvable. You're going to go to court on
I can't.
To present your side to things. It still could. It could be dismissed on the 12th. We don't know.
But you just took my firearm.
Yes, sir.
Is that fair to me and my family?
The judge asked for it. The judge required it.
Is that fair to my? It's not that I have a problem with the judge. The judge already, the court already decided that I was not guilty. And they didn't take my firearms away when I got hit with the stalking charge. And now, here I am with an injunction for a civil bullshit, and now you're taking my fucking gun. How? It's not how's that unfortunate? Tell that to my wife. Tell that to my daughter. Just imagine if somebody kicks in my door tonight and they fucking kill my family. You're gonna be saying, oh, it's unfortunate that you didn't have your gun. Is it unfortunate? It's fucking retarded. Welcome, YouTuber.
Mr. Taylor, we're treating you with as much respect as we can.
I treated you guys with respect, but you guys, yeah, you guys know I'm a fucking YouTuber.
Mr. Taylor, we're treating you with as much respect as we can.
I treated you guys with respect, but you guys stole my
I
firearm.
do not disagree with you. What I said,
Stole my firearm.
we're trying to be
I'm
just
trying.
as professional to you as you are to
Can I walk over? I understand there's the Halo law.
He's-
Can I be within 20? Because I'm just looking for my property receipt.
He's bringing it to you.
Yeah. Can I go within 25 feet? I'm not gonna.
Yeah, you can walk over there with me, man.
Yeah. I'm not here.
He's just typing it up for you.
I get it, dude. I get it, man.
And look, we empathize for you, man. I understand what you just said about, protecting your family and stuff like that. But just understand, I'm not the one that wrote that document. He's not the one.
Did
that
you
wrote
swear an
that
oath to defend and uphold the Constitution?
Correct. But
What they just, what Pinellas County did from 4 hours away, just violated my fucking rights.
So-
And you're sitting.
Take it up with
Yeah, you're gonna have that day in
You gotta
court.
take it up with
You're
them.
gonna have
It's not going to be a day in court. It's going to cost you, the taxpayer, friggin' money. Like I said, man, I have no ill will. I have no nothing.
I just don't want you to be upset at us.
I'm not. It's not that, dude. At this point, you know something? Tomorrow, you might hear about a guy wearing his banana hammock in open carrying, because you know something? If she's gonna try to come after me civilly, I need to make money. So I'm gonna wear my banana hammock in an AR-15 on a corner.
We're not allowed to have any guns
You
right
can't
now.
have any
They
firearms.
get arrested.
Oh, so no firearms?
No
No.
firearms. Do you have any other firearms?
have-
No. I was gonna call my buddy.
So if you have any firearms,
No,
I'm saying like if tomorrow,
No.
this case is clear. If you walk around with a gun,
Well,
you'll get
I've got
arrested, violate your injunction.
Well, right now I have a video I'm about to upload to YouTube, and I was
Past videos. That's
Okay.
past. Anything from here on out, that's different.
Yeah,
Past
okay.
videos, that's
So right now, from here,
from
this
today until this is
and dealt with,
dealt with.
Right.
no guns.
Tomorrow.
I can't call my buddy and say, hey, can I borrow a gun
No,
for a day?
Don't even touch it. Yeah.
All right, fine.
Violate your- you have a copy of it. Read the whole thing whenever you go inside.
Yeah, I'm trying to stay 25. I think I'm 25 feet, right?
You're talking to us right now.
Yeah, and I have no ill will. It's just like, this is fucking bullshit. Notice this isn't me.
Yeah. Who is it?
It's a good friend of mine.
Oh yeah.
Yeah.
Does he live here? Or?
No, he lives up north.
What's the story behind that?
Well, he's up in can't remember. It's either New Jersey or somewhere up there, but he got the same thing. Wanted. And now I guess I have to make a shirt with my face on it that says wanted, because obviously they can't leave me the fuck alone. Dude, I was 9 months with an ankle monitor. Look at my ankle. You see this? You see this? That's a callus. Ankle monitor for 9 months. I go through trial, get found unanimously not guilty, and then here we are again.
Here, take that back.
Thank you. Is there a way I can get the light back? If it's possible. I don't know if it's. It should come off with just like a real. You know the deal.
When this is all done with, you go get your.
Well, dude, that's a $130 friggin' light. I'm like, I get the firearm, but that's not a firearm. That's just an accessory. I appreciate that. Thank you. Appreciate it.
I'm writing still.
Yeah. No, I got nothing but time. Like I said, I have no ill will. I'm not gonna hurt you. I'm not gonna, you know, I've seen too many YouTube videos of people trying to aggressively come after the cops. That's not who I am. You know, if anything, I'm not that person. And then whenever I deal with bad cops, then that's when the bad side of me comes out. You treat me with respect, I'll treat you with respect. But if you treat me like a piece of shit, and not to say you're treating me like a piece of shit.
It sounds like we've been treating you good because you've been
yeah, I'm not, and it's not your fault. It's Pinellas County.
Exactly, man.
They sent you to come here,
We're
which is a bunch of bullshit. But at the same time, you're telling me now I can't have any fire. I can't call my buddy. Second, like, this is all a bunch of bullshit stuff. You know, just imagine if it was you. For being outspoken about, you know, government corruption, government tyranny, government friggin' outreach, all that. Whenever I do that, here we are. I get my rights stripped away from me.
Mr. Taylor argues that the Pinellas County injunction violated his rights, presumably referring to the Second Amendment right to bear arms. In the 2022 case of New York State Rifle and Pistol Association v. Bruin, the Supreme Court held that the Second Amendment protects an ordinary law-abiding citizen's right to carry a firearm in public for self-defense, and that any restriction on that right is constitutional only if the government can demonstrate that it is consistent with the nation's historical tradition of firearm regulation, a standard that significantly narrowed the circumstances in which governments can restrict public carry. Applying this framework, the First District Court of Appeal of Florida struck down Florida's open carry ban in the 2025 case of McDaniels v. State, and the Florida Attorney General subsequently directed statewide non-enforcement, making open carry legal for eligible adults as of September 25, 2025. Now, despite the lawfulness of open carry, under Section 784.0485 of the Florida statutes, any individual who is the victim of stalking may file a verified petition for an injunction for protection in circuit court, and if it appears to the court that stalking exists, the court may grant a temporary injunction ex parte, pending a full hearing, and may grant whatever relief it deems to be proper for the situation. Within 24 hours of issuance, the clerk of court must electronically transmit the temporary injunction to a law enforcement agency in the county where the respondent resides, who must then serve it upon the respondent as soon as possible. Now, as for the constitutionality of using this statute to confiscate Mr. Taylor's firearms, the Supreme Court addressed this question in the 2024 case of United States v. Rahimi, upholding a federal firearm prohibition for individuals subject to domestic violence restraining orders, and concluding that an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed, consistent with the Second Amendment. The Rahimi court's analysis, however, was grounded in an affirmative judicial finding of a credible threat of physical violence, and whether the record here supports an equivalent finding is not clear. Well, absent such a finding, if a court were to conclude that the ex parte issuance of the injunction, which stripped Mr. Taylor of his Second Amendment rights based solely on uncontested allegations and without an opportunity to respond, lacked the historical grounding necessary to meet the Bruin standard, a constitutional violation could be established.
Not happening. Not happening, dude. You could ask me for anything right now other than my first and last name, and you already know that. And like I said, I just need a case number from both St. Lucie and I'll get it from. Oh, you're all St. Lucie. Okay. I just saw a sheriff's. I thought he was Port St. Lucie. Dude, the funny thing is, I was just out open carrying today. That's what I'm saying. I'm like, I just did it today, and is that against the?
You didn't get served the injunction
until right here.
Once you got it served from that point on.
Okay.
He's telling you to come forward.
Yeah, I know. I'm just.
Because I need you to
I know. I get it.
So,
I just want to make sure we're not gonna.
oh, you're good. You're good. You're good. So, this is the property receipt you asked for. Normally, I
Yep.
give one anyway until you shut the door in my face, and I was like, well, what the heck? So there's two of them.
One for you, one for me.
One for you, one for me. Exactly. So, I've listed down Glock with the serial number, Glock magazine, and 14 rounds of 45 caliber. I've already signed my portion.
Can you put hollow points on there? Because I don't want to get a bunch of, freaking bullshit rounds. Because I paid a lot of money for those.
Well, let me look at these rounds. Let me look at
Please.
these rounds.
I'm telling you, man, ammo's expensive. My ball ammo, I don't give a shit about. But whenever I put hollow points into a gun, and it's like $30, $40 a friggin' box, yeah, you best believe I'm gonna make sure I'm getting my hollow points back. Yeah, hollow point, hollow point, hollow point, hollow point, hollow point. All those are hollow points. No.
Well, I've seen the different colors.
Yeah,
Okay, ball ammo
there's one that's I can't remember. One's like.
Yeah, usually we don't list like brands or anything.
Yeah, I'm not worried about the brand. It's just longs or hollow points.
Mr. Taylor surrendered his firearms peacefully, and the encounter ended without further incident. On May 12, 2026, following a motion from Mr. Taylor's counsel, the court amended the temporary injunction with respect to its firearms conditions, and Mr. Taylor subsequently went to the St. Lucie County Sheriff's Office to retrieve his confiscated firearms. After retrieving his firearms from the St. Lucie County Sheriff's Office, Mr. Taylor was openly carrying in Martin County, Florida, when he was approached by deputies from the Martin County Sheriff's Office.
Huh?
Violation of rights or anything like that. However, there is an injunction in place.
Yeah.
Hold on.
There's an injunction. There's an injunction.
You're violating your injunction.
No, I'm not.
We're going to get to the
Right now, online,
I know everything's going on. Listen to me.
I'm not going to fight you guys.
I know
this injunction.
Let me explain it to you.
I was just giving information.
The injunction,
You are not allowed to be in possession of the firearm as of right now.
That just
That is
got
why I'm
overturned.
here.
Can I call my lawyer?
We'll get to that here in a minute.
Yep.
Okay? I will absolutely give you
like,
the opportunity.
Let's walk over here off the roadway, okay?
Yeah. Can you take let me call my attorney.
We'll talk in a minute. We'll talk to the attorney, okay?
Yes, please. Before you actually take me to jail.
We're not taking you to jail yet, but you do have an injunction
I understand.
in place.
I understand that. They just gave me my firearms back.
Who gave you the firearms back?
Friggin' St. Lucie County.
When did they give it to you?
Today.
Okay, perfect. That's why we're trying to get the bottom of it. Because
Call St. Lucie County.
That's why. So like I said,
I understand that there's an injunction. The injunction from the judge said because of all this, because
right
I
now,
never.
I'm going to take this.
Yes. Hold on. Be careful.
is there one on the table?
Yes, sir. I like I said, if you want to take it,
Just for right
I
now.
don't want you to take the firearms, but just
But we're going to.
it's
as of right now.
it's got a nice seal. And that's
How's
why
the whole
just take the whole
all you have to do is pull. No, just it's stuck to my belt. Just pull straight up.
There we go.
There you are.
To the legal side of it.
And then
Like Michael, like I was saying, we were just giving that information. Obviously,
I
we're
get-
getting calls on you.
I get
It's
it.
Fine, what you were doing,
I get it.
but it's the injunction. That's why we're here.
And like I said,
Yep.
I'm
gonna take this off right now.
Yep. Hold on. There's a QD mount.
Mm-hmm. Perfect. Yep, I'll get
And then I'm not, like I said, I'm not resisting.
No, you're not at all. You're good. You are good.
Just gonna pat you down for any more
Yep.
weapons.
I don't have any more weapons.
Wallet, I'm assuming.
Wallet, cigarettes, lighter.
Move your feet apart, Luke. Thanks, buddy. All right.
You good?
Yeah, if you want to sit right here, you're good, man.
I don't know the other one.
Like this literally just happened. Like literally just got him back.
That's why we're gonna. Where's your injunction?
What do you guys want to talk right? Well, right now, they put me in handcuffs because of the injunction. And we just went through the injunction where they gave me my firearms back, and you are the one that orchestrated that. And any one of you that wants to talk to my attorney about this, because I don't want to. I'm not trying to go to jail, but this is Martin County.
Listen, you have an active. You have an active.
I haven't.
Active injunction out of Pinellas County. Which states you can't have firearms.
That's what I'm trying to get at. That's what I'm trying to tell you, is that this injunction just happened.
We just
2 days ago.
Pinellas County, and as of this point, right now, it's active.
It's not active. It just happened.
It is absolutely active.
Yes, sir. I have my attorney, dude.
You can speak to your attorney.
But he's telling you that this just went.
Is this Martin County?
Yes, sir. Like I said, man, I literally just got the hand.
Why did they stop you, Mike?
I was just out open carrying on a sidewalk.
Well, because they ran your name and saw the injunction.
And they saw the injunction, and they said it was still active. The firearms part.
The injunction is active, but the firearms provision is not. That's
Correct. The firearms provision. If you look at letter E on the injunction, letter E says that my firearms have to be returned to me, and they literally got returned to me. I was at the St. Lucie Sheriff's Office. Yes, sir. That sounds good. Like literally at 10 o'clock this morning, I went to St. Lucie to pick up the Glock that you just picked up, that you just took. I literally was just there today at 10 a.m. this morning.
The deputies handcuff Mr. Taylor, claiming that he is violating his injunction, and Mr. Taylor and his attorney explain that the firearms provision of the injunction has been amended. Under Section 784.0487 of the Florida statutes, refusing to surrender firearms or ammunition when ordered to do so by a court constitutes a first-degree misdemeanor, and openly carrying a firearm in apparent violation of an active injunction's firearms provision could provide a basis for arrest under that same provision. Now, it is important to understand that despite the fact that the deputies appeared to be responding to calls about Mr. Taylor openly carrying a firearm, which is entirely lawful in Florida, the issue was not that they believed open carry to be illegal. Rather, they seemed to believe that Mr. Taylor was violating an injunction containing a firearm prohibition that remained active. Although the firearms provision had been very recently amended to eliminate the restriction and allow Mr. Taylor to possess firearms again, it is possible that this updated information was not available to the deputies. And if this was the case, a court would likely conclude that the officer's seizure of Mr. Taylor did not violate the Fourth Amendment, despite the fact that he did not actually violate the injunction. As the Supreme Court explained in the 2014 case of Hine v. North Carolina, a seizure may be permissible under the Fourth Amendment even when the justification for the action is based on a reasonable factual mistake. Accordingly, if a court were to find that the deputy's belief that the firearms provision of the injunction remained in effect was objectively reasonable, given the information available to them at the time, a seizure would likely survive Fourth Amendment scrutiny, notwithstanding the recent amendment to the firearms provision.
Like this flu just happened. Like, you want to see the video of me at the St. Lucie County Sheriff's Office and them giving my firearms back? Bullshit. Looks obviously this is the case. I don't get them off.
It is unclear exactly what occurred after Mr. Taylor was arrested. As of the date of writing this episode, the stalking injunction case remains pending. Overall, the deputies of the St. Lucie County Sheriff's Office and the Martin County Sheriff's Office get an A for conducting themselves professionally throughout both encounters, acting on information reasonably available to them at the time, and for handling a legally complicated situation without unnecessary escalation. Both sets of deputies handled their respective encounters without confrontation, and the Martin County deputies demonstrated a clear understanding that open carry is lawful in Florida, arresting Mr. Taylor not because of the manner in which he was carrying, but because they believed an active court order prohibited him specifically from possessing firearms. Whatever criticisms exist about the underlying injunction framework and its constitutional tension with the Second Amendment rights discussed earlier in this episode, it's not the role of law enforcement to decline to enforce a court order on the grounds that it may be legally vulnerable. Officers are obligated to act on the law as it exists, and the constitutional framework governing mistakes of fact recognizes that officers acting in good faith reliance on a court order that has been modified without their knowledge are not acting unlawfully, even when the arrest ultimately proves unwarranted. In this situation, the injunction was issued in Pinellas County, it was served in St. Lucie County, and Mr. Taylor was encountered in a third county entirely, making it entirely foreseeable that the Martin County deputies would not have had current information about the amendments. This interaction highlights how the intersection of rapidly evolving court orders and multi-jurisdictional enforcement can place officers in genuinely difficult positions, and even, in situations like this, lead to unnecessary arrests based on outdated information. Now, Mr. Taylor also gets an A for exercising his Second Amendment rights lawfully, maintaining a respectful demeanor during 2 separate law enforcement encounters, and pursuing the appropriate legal channels to challenge the conditions of the injunction. Mr. Taylor openly possessed and carried his firearms in compliance with Florida law, and in recognition of the rights restored to him by the amendment to the injunction's firearms provision. During both encounters, he voiced his objections clearly, requested the opportunity to contact his attorney before being taken into custody, and complied physically without resistance throughout. His decision to challenge the firearms conditions of the injunction through counsel rather than through non-compliance was both legally sound and practically effective, resulting in the amendment that restored his rights shortly after the initial injunction was entered. I commend Mr. Taylor for his composure under circumstances that would test anyone's patience, his effective use of legal counsel to vindicate his constitutional rights, and his commitment to documenting these encounters so that the public can evaluate them for themselves. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching.